All right, on page 12, let me swear you in. Sorry about that. Do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do.
All right, thank you. First is Mr. Lovano on page 12.
He's here, present, Judge Amain.
All right, thank you. Good morning, sir. I do find probable cause for petty theft, second degree, first offense.
Buenos días, señor. Considero posición jurídico para el delito de furto menor en segundo grado, primera incidencia.
Mr. Linder, first to you.
Señor Linder.
One moment, Your Honor.
Your Honor, can you get the arrest number or case number?
Yes, of course. It's 5921003449. His first name is Peter.
Okay, thank you.
Okay, thank you, Your Honor. If Mr. Lovano wishes to resolve the case, the offer to be a withholding court costs, no return.
El señor Lona desea resolver este caso, lo que sería en pago de condena y costos judiciales con la prohibición de regresar al sitio de los hechos.
He has prior, so I don't know if he'd be eligible for diversion, but it appears this would be his first theft.
Could you repeat that, Mr. Luna?
He has priors, so I do not know if he would be eligible for a diversion program.
Tiene antecedentes, así que no sé si sería elegible para el programa alterno.
But this would be his first theft.
Pero este sería el primer paso para hacerlo, si lo fuera.
Judge,
Nada más.
Judge, I did speak, Mr. Lovano. I believe this area or this place involves a Walgreens. Regardless of what happens, he does understand no return to the Walgreens.
Señor juez, sí, que este incidente tiene que ver con un Walgreens, independiente de lo que pase, él entiende que puede regresar a ese Walgreens.
Judge, I believe his priors in speaking Mr. Lovano are nothing similar in nature. I believe may potentially possession of cannabis offenses. He works in security. Because this involves a theft case, I'm going to be asking the court an ROR on his behalf.
Creo que el señor tiene antecedentes a los que posiblemente una posesión de cannabis. Dado el hecho de que trabaja, voy a solicitar que sea puesto en libertad bajo libertad condicional.
Does your office need to be appointed?
Judge.
Ya que decide en su oficina.
Do you have his phone number?
¿Tiene el número de teléfono?
I do, Judge.
That's my father's.
Oh, what's your
754 81 41.
Okay, I thought that was yours. The screen cut off. Something happened.
The whole system just went down.
I know it's the judges that cut off because the interpreter is still moving. Okay.
All right, let's try this again. The system just froze.
Oh.
All right, so do you have his phone number, Mr. Romero?
He's getting it as we speaking.
All right, sir, I'm going to release you on your own recognizance,
Y el señor voy a dejarlo en libertad bajo palabra,
but you cannot return to the Walgreens and the police reports. Do you understand?
pero le queda prohibido regresar
Regresar a Walgreens que se menciona en la policial, ¿entiende?
En voz alta, sí.
Yes.
Yes.
And it will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply.
Y voy a designar a la oficina de los defensores públicos para que lo representen. Y una vez que pase la pandemia COVID, tiene que nuevamente la hacer.
Anything else in this case?
¿Alguna otra caso? No sé.
En este caso,
No, Judge.
No, señora
no,
juez.
señor juez.
Este es nuestro número de defensor público. Cuando sales para hablar con tu abogado, este número llamas, ¿ya?
Our next Spanish interpreter case at Maine is Mr. Lopez on page 22. First name is M-A-R-B-E-N, Mr. Rojas, and his number is 5821000201.
Thank you, Your Honor.
You're welcome. Oh, it looks like they froze again.
can't hear anything.
By the way, Your Honor, it's very difficult to hear,
She's
Mr. Romero from where I am.
We're going to
reset the whole
shut down
system.
again. We're going to be back on the regular system tomorrow. It's because we had technical issues all week that we're on.
All right.
We're going
Oh,
to.
she had her microphone off. That's why we couldn't hear her.
Okay, so we shut down again. So hopefully we're back up now. Okay, so this is on Mr. Lopez on page 22 then.
Señor López, página 22.
Okay, I do find probable cause for possession of cocaine and trespass.
Siendo que existen indicios probables para los delitos de posesión de cocaína y entrada ilegal en una propiedad.
Mr. Linder, first to you, please.
Señor Leder, primero usted, por favor.
Por favor.
Your Honor, recommending an R1 pretrial random testing.
Recomendaría libertad habrá medidas cautelares y pruebas sin aviso de sustancias.
No objection, Judge.
No hay objeción.
No hay objeción, su señoría.
I'm going to be asking to be provisionally appointed, and I do have his phone number.
Solicitamos
Solicitamos designar provisionalmente y si tengo el número de teléfono.
His phone number is 54
Sorry.
422 8766.
What were the first three?
54
It broke up again.
754
5-4.
754.
Okay, did you get them, Ms. Worrell?
La apuntó, señor Warsky.
All right, sir, you cannot use any drugs or alcohol while your case is pending because you are going to be randomly screened while your case is pending. Do you understand?
A usted se le prohíbe usar drogas o
Su caso pendiente sustancias, de todo dependencia de su caso, ¿entiende?
¿Sí, entiendes?
Yes.
You also cannot return to the restaurant and the police reports. Do you understand?
tampoco puede
Regresar al restaurante que necesita los informes policiales, ¿entiende?
¿Entiendes? Más alto.
Okay, and I will provisionally appoint the office of the public defender.
During the pandemic, sir, once COVID is over, you will need to reapply to make sure they keep representing you.
Y si voy a designar provisionalmente a la oficina de defensores públicos para representarlo, señor, una vez que termine la pandemia, tendrá que presentar nuevamente la solicitud para que lo represente.
All right, good luck to you, sir. You're going to be released a pretrial release and you need to call in tomorrow morning before 11 a.m.
Buena suerte, señor, que han libertado bajo medidas cautelares. Tienen que reportarse con la oficina de medidas cautelares a más tardar mañana a las 11 de la mañana.
Anything else on his case?
¿Alguna otra cosa en este caso?
Okay, thank you.
Bien, gracias.
So that's it for main jail. Mr. Farberic, we did not have any interpreter cases at any of the other jails, correct? Okay, thank you. Thank you so much, Mr. Rojas. Have a great day. Okay, so we just finished our DV cases, so that brings us to page 11. Mr. Alvarado.
Mr. Joseph Alvarado, come on up, please.
All right, Mr. Alvarado, good morning. Mr. Linder and Mr. Farberic, is there any legal objection why I cannot find probable cause for aggravated battery, deadly weapon? It's alleged the victim was stabbed in the hand.
No, Judge.
Yes. You're muted. You're muted.
Judge, there's no indication. It just indicates that she was stabbed. It doesn't indicate what the weapon, or if it was a weapon, or if it was a fingernail, or it says unknown weapon, but it doesn't specify. And it doesn't say anything with regards to the injury other than a scratch. So I would object to the court finding aggravated battery.
Actually, it says a fresh scratch on the victim's neck and a fresh cut on her left hand where it indicates she was stabbed. So over the defense's objection, count one, I do find probable cause for aggravated battery, deadly weapon. Count an out-of-county hold from Hendry County that you're being held no bond on, that I have no jurisdiction over with regards to count one. Mr. Linder, first to you.
Judge, I'm recommending a $5,000 bond, no victim contact, no possession of any weapons. Your Honor, this is based not only on the court's finding made this morning, but additionally, in the alternative, this matter could be potentially upfiled to a felony battery due to priors, be it a 2007 battery. He also had 2008 burglary of a dwelling and theft. He violated probation, was sentenced to just over 34 months state prison. 2009 grand theft, same sentence. Also noting, it would appear that he failed to appear in court in another county, and that's why he has a no bond hold.
Thank you, Mr. Romero.
Judge, I spoke to Mr. Alvarado. He's disputing the allegations or the findings that the court made. I did advise him right now. He'll have his day in court to present an evidentiary a motion. But my understanding is the alleged victim, basically the injuries that are in her hand as a result of self-injecting. She's a drug user. Let me do the talking. You don't do the talking. She's a drug user, and that's how she uses an injection to get the drugs into her system. I believe that's what the officer suspected, and that's why he didn't charge her with the felony and just charge her as a misdemeanor battery. So for mitigation purposes, Judge, I do realize he has a no bond hold. There's nothing the court can do. He has to wait till that county comes and picks him up, but I was going to be asking for the court just to leave the standard bond in place.
All right, thank you. So I'm going to set bond in the amount of $3,000 on the aggravated battery. The conditions of your bond, even while you're in custody, sir, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yeah.
That means that not only can you not call her, you cannot send her letters, email, to social media, have a family member or friend send a message to her, or any other means of communication I have not said. Understood? You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
All right, good luck to you, sir. You'll also have to go to Hendry County to answer to that out-of-county hold. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic on count one. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case? All right, good luck to you, sir. Next is Mr. Cleary on page 11.
He's approaching, Judge. Me?
All right, thank you. All right, Mr. Cleary, good morning. I do find probable cause for trespass. Mr. Linder, does the state have an office?
No, Your Honor, I'm gonna ask that the court transfer this case to Judge Lorenz MI division with an order of no return. I checked, Mr. Cleary has at least one pending case in mental health at the moment.
Okay, thank you, Mr. Romero.
Judge, my understanding is, in speaking to Mr. Cleary, he doesn't have much contact with the criminal justice system from what he advised. He is homeless. I did ask him as far as the nature of these allegations. My understanding, he has no prior convictions on his record. We were going to be asking for the court to consider an ROR on Mr. Cleary's behalf.
What about the state's request to send him to mental health court because he has another pending case there?
Let me ask. One moment.
Thank you.
Yeah, also to further advise the court, Mr. Cleary was released in division to pretrial standard. He was released out of pretrial standard supervision May 11th of 2020, and he have not reported in any way, shape, or form for his intake. This morning, when I noticed it, I advised the pretrial officer that the case is assigned to, that a warrant was done. So a warrant went over to Lorna Rain this morning for signature.
Okay, thank you.
Judge, we didn't hear anything what pretrial was advising the court.
He was advising me that pretrial submitted a warrant this morning to his division judge, Judge Lerner Wren, based on not only this new arrest, but the allegation that he never reported when he was released on May 11th of 2020.
Do you know what was the charge on the case that he's currently out on supervision?
Trespass property.
She's looking.
It looks like his pending case is before Judge Lorenz trespasses.
Other trespasses.
Yes.
He's got more than one. All right, so I will leave the bond in place and transfer this case as well to Judge Lerner Ren's Mental Health Court with an order of no return. I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Once COVID is over, he'll need to reapply if this case is still pending. Good luck to you, Mr. Clary. Next is Mr. Kimball on page 11.
Judge, he bonded.
All right, thank you. I do find probable cause for his KPS for petty theft. For the record. Okay, so next is on page 12, Mr. Voos, how do you say your name, sir?
Now,
All right, Voos, sorry about that. All right, I do find probable cause for trespass. Mr. Linder, does the state have an offer?
Your Honor, I do. The offer's an adjudication, 5 days in Broward County Jail, no return. And Your Honor, while I normally don't make jail offers on these type of charges, Mr. Voos is just causing disturbances to this business, to the owners of this business, to the patrons of this business. And the owner of this business has a right to conduct his business without being disturbed. Your Honor, as mentioned in the report, Mr. Voos was just trespassing this location July 7th. He was then arrested July 10th, and he pled out at first appearance to time served. He was also arrested January 25th of this year at this same location in trespass one. I'm noting in this PC affidavit, it wasn't just a matter of him standing around and being somewhere where he wasn't supposed to be. He was causing a disturbance. He's had this is his 8th arrest in the past year and a half, 21 in the past 10 years, Judge.
Thank you, Mr. Rivera.
Judge, thank you. My understanding, Judge, he is homeless. No one's going to be able to afford to post his monetary bond, Judge. He did advise me that in exchange for his no contest plea and giving up his right to have a trial, he would like to invite the court into plea negotiations. Ask if the court would consider extending an offer of time served. This is a trespass, Judge. He is giving his right to dispute these charges. He is taking responsibility. But he's asking if the court would consider extending an offer of time served.
I will not actually get involved. I'm not going to do any better than the state's offer.
Let me talk to him, Judge.
All right, thank you.
Already what, about 2 days in?
Judge, at this time, he wishes them to accept the state's offer.
All right, thank you. Sir, please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and please state your name for the record.
D'Angelo Booth.
All right, sir, my understanding that you wish to resolve this trespass case, correct?
Yes, ma'am.
And do you understand the charge against you?
Yes, ma'am.
Do you understand everything that's happened here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
And do you need more time to speak to your attorney?
No, ma'am.
And do you understand you have a right to go to trial and fight this charge, but you're forever giving that up by accepting the state's offer?
Yes, yes, ma'am, because well, you know what? Yes.
And have you ever been treated for a mental or emotional illness?
Yes, I have. Bipolar, schizophrenic, schizophrenical.
Okay, and is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
And you understood everything that's happened so far?
Yes, ma'am.
All right, and how do you wish to plead, sir? Guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given. I also find there's a factual basis for this plea based on the probable cause affidavit. I am going to sentence you to an adjudication of 5 days in the Broward County Jail with an order of no return once you get out. And how much time does he need to pay?
Judge, we're going to be asking for a civil lien.
All right, and I'll convert your court cost of prosecution, PD application fee to a civil lien. What that means, sir, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay that off. Good luck to you, sir, after your 5-day sentence with all your credit for time served. You will be released. How many days in does he have? 2?
Judge, we just put 5 days Broward County Jail with credit time served, and we'll calculate the credit. He'll get 1 day and he'll be released on the 17th.
Okay, thank you. All right, good luck to you, sir. All right, next is Mr. Morales on page 12.
He's approaching Judge Maine.
All right, thank you. Mr. Morales, good morning, sir. I do find probable cause for petty theft, first degree, property over 100, less than 750. I do note it is a listed victim, not a business. So Mr. Linder, what's the state's recommendation as to bond?
Your Honor, I spoke with Mr. Hoover this morning. I'm going to be recommending that Mr. Morales be transferred to Judge Lineren's Mental Health Division. I can see we ran his CCIS. He's on 3 prior occasions. He's been ordered to mental health treatment out of Palm Beach County. Mr. Hoover would have no objection to the court transferring the case to mental health. He actually would support that because he does believe Mr. Morales, based on what law enforcement advised him, he does believe Mr. Morales needs some assistance, Your Honor. He would be opposing just a straight time served order because he believes that more is appropriate here, as he's been advised that there's been issues with Mr. Morales in the neighborhood, that his bike was taken from his property. He also thinks he may want to address the court at a future date. So under Marcy's law, it's another reason I'm unable to make an offer at this time, Your Honor. I can advise the court, Mr. Morales was just arrested July 2nd of this year in Hollywood at East Young Circle. He was ROR'd at his first appearance. So I'd ask that the court keep the bond in place with an order of no victim contact, no return, and a transfer to MI division. Nothing further.
Thank you. Mr. Romero?
For Mr. Morales, I do have severe mental health concerns. I'm going to be asking for mental health screening. He is homeless. He can't afford a bond. I'm going to be asking for this case to be transferred to Judge Lerner. Obviously, Judge, at this time, since it's nonviolent, I am going to be requesting an ROR, but I do understand where the court's coming from if the court wanted to leave the bond in place.
All right, I am going to leave the bond in place with a transfer to mental health court. This was allegedly taken from a victim. So instead, it's not a business crime. The crime is a person. So I will sign that mental health screen, and I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Once COVID is over, he'll have to reapply to make sure they keep representing him. I am going to order no return to the incident location and no contact, direct or indirect, with the listed victim. Mr. Morales, direct or indirect, no letters, no phone calls, no having a family member or friend send a message or any other means of communication, even if you don't know the listed victim. Okay, good luck to you, Mr. Morales. We're going to get you a doctor to talk to, sir. All right, next is Mr. Franco on page 12.
He's a refusal, no legal objection, Judge.
All right, thank you. We're proceeding. These are out of county holds for child support from 2 separate counties. He has Lee County child support in the amount of $376 and Charlotte County child support in the amount of $365. He needs to pay both of those purges to be released. Next is Mr. Joe on page 12, who waived.
Correct.
All right, thank you. I find probable cause for his out-of-county hold from Kendry County for reckless driving. He's being held no bond and for a failure to appear. Anything else on Mr. Joe?
No, Judge.
Okay, thank you. That brings us to page 13. Mr. Valdez Roman has bonded for the record.
Sorry.
Mr. Valdez Roman has bonded. I do find probable cause for driving under the influence of alcohol or drugs, second offense, refusing to submit, operating without a valid DL, and driving with license suspended. Next is Mr. Simmons on page 13.
He's here, present, Judge, right next to me.
All right, thank you. I do find probable cause for resisting an officer with violence. Any legal objection based on the allegations that he headbutted the officer?
I'm sorry. I was just saying the resisting with violence, it's the statute specifically states offering violence. It doesn't have to make contact.
Correct. He tried to, but the officer stopped him mid-headbutt. That's okay. All right, thank you. Without objection, I do find probable cause for resisting an officer with violence. So Mr. Linder, first to you.
Judge, I'm recommending $1,000 bond. I'm showing that Mr. Simons is, he has a pending 2017 case for battery on a law enforcement officer resisting with violence, 2 counts of DUI property damage, 1 count of DUI. He also had a 2019 resisting without violence, trespass, and disorderly intoxication.
What year was that pending, that Leo?
2017, Your Honor, and I believe it's before Judge Merrigan Veterans Court.
Okay, thank you. All right, thank you. Mr. Romero?
Judge, and speaking of Mr. Simons, he is working, he has a place to stay. He lives in Hallandale, Judge. More importantly, from what he advised me, there's no one that's going to be able to post his monetary bond. Judge, we were going to be asking for the court to consider releasing him our award of pretrial. He will be coming back to court to face these allegations, Judge.
All right, thank you. He's not a candidate for a straight pretrial because of the pending charges of a similar nature. I am going to set bond in the amount of $1,000. Once you do post bond, you are going to be supervised by pretrial, though, because the alcohol influence box is checked off, sir. That means that you cannot use drugs and you cannot use alcohol while your case is pending. Do you understand?
Yes.
You are also going to be randomly screened for drugs and alcohol while your case is pending. And Mr. Romero, does your office need to be appointed?
Yes, Judge.
All right, thank you. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case?
No, Judge.
Good luck to you, sir. Next, Mr. Benitez on page 13 is a first-time refusal because it is not a crime of violence. He's being reset one time as a courtesy. Next is Mr. Spear on page 14.
He's approaching, Judge. How you doing, Your Honor?
Okay, thank you. I'm fine. Thanks for asking. I do find probable cause. You have 2 capiases, leaving the scene of an accident and operating without a valid driver's license. Your bonds are $1,500 and $500. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic on both of these cases, bringing them here from the satellite division. So you'll have to file a motion with your division judge based on the leaving the scene. I don't believe there's an offer today, correct, Mr. Linder?
Correct, Judge.
Okay, so anything else on his case we need to address?
Yes. My understanding, speaking with Mr. Spear, he advised me basically in the beginning of July, he suffered a motorcycle accident and he was hospitalized for 7 days. He advised me that is the reason why he missed court. It wasn't that he willfully missed court. He's asking based on that if the court would consider releasing him on pretrial release today.
Give me 1 minute. What was the date?
He advised me he suffered the accident July 1st and he was hospitalized for 7 days.
Okay, you missed court on June 26th, so that will be denied. Good luck to you, sir.
Judge, would you sign a phone order?
I will. All right, let me add that in there, phone order. All right, not a problem. Next on page 15. Mr. Mustafa.
Is Mustafa back or is he still in?
We put him towards the end.
Still in court.
Court.
Okay, we'll come back to him. Thank you. All right, next, I just was hoping he'd be back. No problem. Next on page 16, Mr. Mays.
The approaching judge here at Maine.
Okay, thank you. Mr. Mays, good morning, sir. I do find probable cause for robbery by sudden snatching without a firearm or weapon. Count 2 is a pretrial warrant that you're being held no bond on that I have no control over. So with regards to count 1, Mr. Linder, first to you.
Judge, I'm recommending a $7,500 bond, pretrial release of the GPS monitor, level 2, no victim contact. Your Honor, while I certainly recognize that he was on pretrial already and violated, my concern is that there was appears to be a relationship between the 2 parties in the robbery. Mr. Mays in 2002 had a kidnapping with 3 counts of sexual battery, 1 count, 2 counts with using great force or weapon. He was sentenced to 11 years in state prison. It would appear that he is a registered offender, Your Honor. He also has another pending possession of substituted cathinones in addition to the case that he's being held no bond on. Nothing further at this time.
Okay, thank you, Mr. Romero.
Judge, Mr. Mays is working. He's employed at a car wash, only making about $75 a day. Based on his financial resources, Judge, this is a third-degree felony. I'm asking for the court to consider a $2,500 bond on count 1 and to provisionally appoint our office.
All right, thank you. I do find it aggravating. It's alleged that he took the phone from the listed victim while she was on the phone with police. I don't know what led up to that, but that does give the court concern for her safety. Also, the allegations that he was previously convicted of kidnapping and 3 counts of sexual battery, for which he served 11 years in Florida State Prison, which I am taking into consideration. I am going to set bond in the amount of $7,500. Once he posts that bond, he's going to be supervised by pretrial release level 2 with a GPS, finding it necessary to protect the listed community from Mr. Mays. Sir, even while you're in custody, the conditions of your bond and release are that you cannot have any contact, direct or indirect, with the listed victim, your ex-girlfriend. Do you understand? That means that not only can you not call her, you cannot send letters, you cannot have a family member or friend send a message or any other means of communication that I have not said. Do you understand? Is that a yes? All right,
Yep.
Also based on the relationship between the parties, you cannot possess any firearms, weapons, or ammunition while your case is pending. Understood? He's soft-spoken.
Yes, ma'am.
All right, sir, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, Mr. Mays. All right, next is is it Musin on page 16?
That's your last name, sir?
She said it right.
Oh, she said, Judge, you're,
Oh, okay, thank you. Oh, good. I'm glad I got it. All right, sir, good morning. I do find probable cause possession of burglary tools with intent to use, false ID to Leo, loitering or prowling, and resisting without violence. Mr. Linder, first to you.
Judge, I'm asking that the court keep the bond in place with an order of no return. I'm showing Mr. Musin has a warrant right now out of the state of California from May 10th of this year for assault with a deadly weapon, great bodily injury likely, and contempt of court disobeying a court order. Nothing further.
Okay, thank you. Mr. Romero?
Judge, I believe if I heard this state correctly, they're asking for the bond to be, remain in place at this time. No objection. We're going to be asking to be provisionally appointed.
Okay, thank you. All right, so I will leave the bond in place with an order of no return. Sir, do you understand?
Yes, ma'am.
All right, you can't go back to the alleged incident location, and it's $1,000 bond. Problem I'm having is that the drug influence box was checked off too. All right, so once you post bond, you're going to be supervised by pretrial release of the allegations that were allegedly at 3:55 in the morning. So you're going to be supervised by pretrial release once you post bond. You cannot use any drugs, you cannot use any alcohol, and you will be randomly screened for drugs and alcohol, sir. So once you post your bond, you have to call on the next business day before 11 a.m. Understood?
Yes, ma'am. Yes, ma'am.
All right, and I'm not sure if I said this, but I'll provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, sir, you'll need to reapply to make sure they keep representing you. Ms. Worrell, do you want his phone number now?
Go ahead.
All right, whenever you get a chance, please give a pretrial your phone number, sir.
Your phone number right now.
754-801-0835. That's my cell.
You got it?
You got it.
All right, good luck to you, sir.
Thank you.
All right, next is Mr. Summers on page 16.
He's approaching.
All right, good morning, sir. Do either of the parties have a legal objection to a dwelling? It's alleged this is the victim's fenced-in backyard.
No, Judge.
All right, without a legal objection, I am going to change it and make a finding that this is, I find probable cause for burglary of an occupied dwelling. Count 1, count 2, petty theft, second degree, first offense. Mr. Linder, first to you.
Showing a DUI 2016, possession of cocaine 06. Considering this was someone's home, Your Honor, I'm recommending a $10,000 bond. No victim contact, no return, nothing further.
Thank you, Mr. Romero.
Judge, my understanding, I haven't read the PC affidavit. I know Mr. Summers has advised me he's looking forward to having his day in court, but I believe this is basically jumping over the fence and going in the backyard and not making his way into a home or anyone making their way inside the home. Considering that, Judge, he's self-employed. He paints. He doesn't make very much money. He's been here his whole life. He lives in Deerfield. The last time he had contact with the criminal justice system was, I believe, several years ago. But as you've heard, nothing violent in nature and nothing similar in nature recently. Having said that, he's living in Deerfield with his mother. His mother's going to try and get the funds together to try and see if she can help post his monetary bond. We're going to be requesting a $2,500 bond on his behalf, Judge.
All right, thank you. And does your office need to be provisionally appointed?
Yes, Judge.
All right, thank you. So I will set bond in the amount of $7,500 on count one with an order of no return to the incident location. Do you understand?
Yes. Yes.
All right, you also cannot have any contact, direct or indirect, with the listed victims, sir. You may not know who they are, but you cannot call, send letters, have a family member or friend send a message, or any other means of communication that I have not said. Understood?
Yes, ma'am.
All right, I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case we need to address?
No.
Good luck to you, sir. Next is Mr. Bennett on page 17, who's refused, but there was no legal objection why we could not proceed.
Correct, Judge.
All right, thank you. I do find probable cause for possession of oxycodone and his probation violation that he's being held no bond on. On count one, I'll leave the bond in place at $1,000, and I will provisionally appoint the Office of the Public Defender to represent him on both cases during the pandemic. Anything else on Mr. Bennett?
Judge, can I have a mental health screening in the department's motion?
All right, no problem. I'll put that in the findings, mental health screen. All right, thank you. All right, next is Mr. Moreland on page 17. It's a big one, sorry. All right, Mr. Moreland, good morning. I do find probable cause for burglary of an occupied conveyance unarmed. Count two is a burglary of an unoccupied conveyance unarmed. Mr. Linder, first to you.
Judge, while I don't see a history, I'm recommending a $5,000 bond on the burglary of an occupied conveyance. I do have safety concerns based on the allegation that it would appear he consciously broke into a woman's car while she was sitting in the vehicle. On the unoccupied conveyance, I'd be recommending a $1,500 bond. No victim contact and no return on both counts.
Okay, thank you, Mr. Romero.
Mr. Moreland's been residing in our community his whole entire life. He just managed to get a job. He got employed with Advanced Auto Parts, only making $11 an hour, but unfortunately at this time he is homeless. He has no one to help post his monetary bond. He's asking if the court would consider releasing him ROR to pretrial, and we're asking to be provisionally appointed.
All right, thank you. Based on the allegations that the listed victim, one of the listed victims was in the front driver's seat when he allegedly entered her car, know that he's not a candidate for pretrial based on this randomness and these sets of allegations. I will set bond on count one at $5,000, on count two $1,000. Sir, the conditions of your bond are that you cannot return to the incident location, the Wawa, and the police reports. Do you understand?
Yes.
Not have any contact, direct or indirect, with either of the listed victims. Do you understand?
Yes, ma'am. A little louder. Yes, ma'am.
All right. Although you may not know them, sir, you cannot call, send letters, have a family member or friend send a message to them, or any other means of communications that I have not mentioned. Understood?
Ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Moreland. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else in his case that we need to address?
Nothing else, Judge.
Good luck to you, Mr. Moreland. All right, next is Mr. Ellis on page 18.
Approaching Judge Main.
All right, thank you. Mr. Ellis, good morning, sir. I do find probable cause. Count one, trafficking in oxycodone, 25 grams, but less than 100 grams. Count two, possession with intent to sell or deliver alprazolam or Xanax. Count three, possession with intent to sell or deliver amphetamines. Count four, possession with intent to sell or deliver heroin. Count five, possession with intent to sell or deliver cocaine. Count six, possession with intent to sell or deliver amphetamine. Count seven, drug paraphernalia. Count eight, traffic infraction regarding driving on the wrong side of the road. Not for me. Count 9, possession with intent to sell or deliver fentanyl. Count 10, possession of weapon or ammunition by convicted felon, completely separate incident date. Signed warrant regarding a shooting involving Mr. Ellis and Ms. Worrell. First to you, ma'am.
Be honest, the defendant is currently out on pre-trial in case number 213153 CFNA. Count 1, possession of a weapon or ammunition by convicted felon. Count 2, distribution or delivery of cocaine. Count 3, resisting officer without violence. This time we're going to request a revocation of his incident case. He also posted a total bond of $11,000. Bond on count 1 and 2 were set at $5,000 each. Bond on count 3 was set at $1,000.
Okay, thank you. So at this time, I am going to grant pretrial's request. He's going to be held no bond on 213153 CF10A. Charges are firearm by felon, delivery of cocaine, and resisting without violence. Mr. Linder, first to you on the other counts, sir. I know that the reports indicate he has a 2008 conviction for second-degree murder.
That's correct, Judge. Your Honor, I'm asking that the court keep all the bonds in place, including the bond that Judge Bailey set on the arrest warrant, noting that he also has a pending possession of firearm, unlawful possession of firearm offense that you just revoked his pretrial on. That is correct, Your Honor. And he had a 2007 murder in the second degree that he was convicted on. He violated probation. He was sentenced to 12 years in Florida State Prison. He was just released February 15th of last year. That is why, Your Honor, even though the court is revoking his pretrial, I do believe he poses a danger to the community if he is released under any circumstances. So should he be eligible for release on the trafficking case and or the firearm offense, I would also ask that he be again supervised by pretrial with a GPS monitor level 1, no possession of any firearms, weapons, or ammunition. Nothing further.
Thank you, Mr. Romero.
Judge, I understand the court revoked his release on the pending case. He's going to have to go in front of his division judge to seek some sort of relief. If he does manage to seek some sort of relief, he would like this court to address count number 1. There's no way he's going to be able to afford $500,000 bond. I believe the state wanted to have him supervised on level 1. We would have no objection with that, but we would ask also in exchange for level 1 if a bond reduction from $500,000 to $50,000. I know in speaking to Mr. Ellis, he did advise me. He is employed. He's a musician. Doesn't get paid all that much. So that's the basis of why we're requesting a bond reduction of $50,000 rather than $500,000.
All right, thank you. I understand your request. That will respectfully be denied, not only based on the prior murder conviction for which he was just released from Florida State Prison last year, but also his confession to being a drug dealer. I'm leaving the bonds in place with pretrial release level 1 with a GPS should he post bond, strict house lockdown. You cannot possess any firearms, weapons, or ammunition while your case is pending. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Ellis. Once COVID is over, you will need to reapply to make sure they keep representing you. I will reduce however, count 7 and ROR because it's a drug paraphernalia. Good luck to you, sir. I'm sorry, ma'am?
Both cases, because count 10 is the AF warrant.
Yes, on both cases. On count 10, on that case as well, it's also pretrial release level 1 on all cases, all counts.
No firearms, weapons, or ammo.
Yep, I already said that too.